I'm attorney Emily Anderson with RSH Legal. In order for something to be a work injury in Iowa, it must happen at work, have some relationship to the work activities, and be medically caused by work activities. While some injuries may appear to be work-related, that is not always the case. Let's talk about some of the injuries that are not covered by workers' compensation. Number 1, pre-existing conditions. Injuries and health impairments common to the aging process or caused by normal wear and tear are not covered by workers' compensation. If your injury pre-existed your work activities, unless it was made substantially worse by work, it is not covered. Injuries that come on over time may be considered work injuries. These are called cumulative trauma injuries. However, if your work is not the medical cause of these injuries, even though you may feel pain at work, you may not have a work injury under the law. Number 2, injuries that do not arise out of your work. There has to be some connection to your injury and your work activities in order for you to have a workers' compensation claim. For example, if a person has a heart attack while at work, unless the heart attack was caused by the work activities, just because you're at work while it happens doesn't make it a work injury. Number 3, injuries that do not happen in the course of your work. There are many situations where an injury seemingly occurs while at work, but because of the nuanced workers' compensation laws, it falls outside of a covered injury. This can include injuries that occur during certain breaks and meal times, or when you are traveling to or from work. If you are a traveling employee or provided a work vehicle, whether you are in the course of your employment at the time of your work injury has a more lax set of rules. Number 4, injuries where the employer has a legal defense against the injury. Employers have some legal defenses that will bar your work injury claim. The first is an injury resulting from a willful intent to injure yourself or another. This includes injuries as extreme as death by suicide to minor injuries resulting from punching a wall out of anger. If the Injured Workers Act is a result of a work injury, it may still be compensated. For example, if an injured worker develops depression as a result of a work injury and subsequently commits suicide, if there is a causal link between the injury and the suicide, the injured worker's family may be entitled to workers' compensation death benefits. The second defense is that a willful act of a third party causes the injury. This occurs where an injury resulted from a personal attack against the employee. This occurs where the injury results from some spite or grudge or ill will harbored by a third party against the employee personally. The third defense is intoxication. If an injured worker has a positive drug or alcohol test after a work injury, it is presumed the substance in the injured worker's system was the cause of the injury and the claim will be denied. However, the injured worker can overcome the presumption by showing either he was not intoxicated or the substance found in his system was not the cause of his work injury. The situations I just discussed were only a few of the circumstances where a work injury would not be covered. Whether you have a work injury that may fall into an exception is extremely fact-specific. Don't take the insurance company's word for it that your injury falls outside the workers' compensation system. It's important to have a consultation with an attorney to see if your specific situation is covered under Iowa workers' compensation law. If you have further questions about your work injury, please reach out to an experienced workers' compensation attorney at RSH Legal by calling 1-800-433-0283.